Your landlord just broke the law, and they are counting on one thing that you never find out. Last year, a woman in Ohio paid her rent every single month for 3 years. Never missed once, never complained, and when she finally moved out, her landlord kept every penny of her deposit, all of it. He said the apartment was damaged. She had photos proving otherwise, but it didn't matter because she didn't know the one thing that would have changed everything. That landlord had already broken the law before she even packed her first box. And that broken law could have put over $4,000 back in her pocket. This is not a rare story. This is happening right now in apartments across the United States, the United Kingdom, Canada, and Australia. Landlords are doing something quietly illegal, and most tenants walk away without ever realizing they had the power to fight back. Stay with me, because by the end of this, you will know exactly what your rights are and exactly what to do if this ever happens to you. Most people think the rental system is designed to protect both sides equally. It is not. For decades, landlords have operated under one assumption: that you don't know the law, and that assumption has made them a lot of money. But here is what they don't tell you. The law, the actual written law, is not on their side as much as they want you to believe. The moment you sign a lease, your landlord takes on legally binding obligations, not suggestions, not recommendations, obligations. And the most commonly violated one is something almost no tenant ever thinks to check: the security deposit deadline. In most U.S. states, your landlord has a legally defined number of days to return your deposit after you move out. This is not optional. It is written into state law, and most landlords are quietly betting that you have never read it. In California, 21 days. In Texas, 30 days. In New York, just 14 days. In the UK, your deposit must be held in a government-approved scheme and returned within 10 days of agreeing on the final amount. In Canada, each province sets its own deadline, and they all have one. Miss that deadline by even 1 day, and everything changes. In several U.S. states, a landlord who fails to return your deposit on time loses their legal right to make any deductions at all. In California and Massachusetts, you may be entitled to up to 3 times the original deposit as a penalty, plus legal fees. That is not a loophole. That is the law, sitting there quietly, waiting for someone to use it. Pro tip: from the moment you hand over a security deposit, keep a written record of everything. Every payment, every receipt, every message, not because you expect trouble, but because in any dispute, your paper trail is not just helpful. It is often the only thing that matters in court. But the deposit is only one part of this. There is something else landlords do, something far more common, that most tenants simply accept without question. Entering your home without notice. Your rental is your home, and the law protects your privacy inside it. Even if your name is not on the deed. In most U.S. states, UK law, and Canadian provinces, your landlord must give you at least 24 to 48 hours written notice before entering, for any reason: inspections, repairs, viewings. The notice is required. A landlord who enters without notice has violated your legal right to quiet enjoyment, and depending on your location, that violation can be grounds for terminating your lease without penalty or pursuing compensation. Pro tip: if your landlord has ever entered your home without proper notice, Document it immediately. Write the date and time in an email to yourself, or even better, send a message directly to your landlord, referencing what happened. That message becomes a time-stamped legal record. And courts take those records far more seriously than most people realize. Now, here is where it gets important, because these are not isolated issues. There is a pattern, and once you see it, you cannot unsee it. Illegal deposit deductions, unlawful entry, failure to maintain safe living conditions. Retaliatory rent increases after a complaint. Withholding heat or hot water, every single one of these is illegal in every country we cover on this channel. And yet, they happen every single day, because landlords know that most tenants don't know their rights. So, let's fix that right now. If you believe your landlord has violated any of these laws, here is exactly what to do. First, document everything before you say or do anything else. Photographs with timestamps, screenshots of every message, a written personal record with exact dates and descriptions. Do this immediately. Memory fades. Documents don't. Second, send a formal, written notice to your landlord. Not a phone call, not a casual text, a written letter or email that clearly states what happened, which law they violated, and what you are requesting. Keep your tone calm and factual. You are not angry, you are informed. That distinction matters more than you think. Pro tip: the way you phrase that letter matters legally. Use the words "formal notice" in the subject line. Reference the specific law by name if you can find it, your state's Landlord-Tenant Act, or your country's housing legislation. A landlord who receives a letter referencing actual law responds very differently than one receiving an emotional message. You are not upset, you are prepared. Third, if your landlord does not respond, file a complaint with the appropriate authority. In the US, your local housing court or state attorney general's office. In the UK, your local council's housing department. In Canada, your provincial residential tenancy board. In Australia, your state's fair trading office. These systems exist exactly for situations like yours. They are free, and they work. Fourth, for deposit disputes specifically, small claims court is often the fastest path. You do not need a lawyer. You need your documentation, your original lease, and the written communication trail you have already created. Many tenants have walked out of small claims court with double or triple their original deposit, simply because they showed up prepared. Pro tip: before you file anything, search online for your specific state, province, or country's landlord-tenant legislation. Search for your state name, followed by security deposit law. Most official government housing websites list exact deadlines, penalties, and procedures. This takes 15 minutes, and those 15 minutes have saved people thousands of dollars. Here is the truth: most landlords hope you never sit with long enough to understand. The law was written to protect both sides, not just the person who owns the building. You have rights that are just as legally enforceable as your landlord's right to collect rent. The problem has never been the law. The problem has always been awareness. Most tenants walk away from unfair situations not because they lost, but because they never knew they could fight. You know now. So, here is what I want you to do. Right now, before you close this video, check your lease. Check your country or state's deposit return deadline. And If your landlord has already missed it, you may already have a legal case sitting unopened. Drop your country in the comments below. Tell me your situation. Next week, I am going deeper, covering the specific laws in your location that your landlord is most likely violating right now. And if someone you know is renting, send them this video, because the law only protects the people who know it exists. One more thing before you go. Next week, I am covering something that even most lawyers rarely talk about openly. It involves a clause that exists in almost every standard lease agreement, one that most tenants sign without reading, and one that can legally trap you into paying money you never owed. I think you are going to want to see that. Like this video if it opened your eyes. Subscribe so you don't miss what's coming, and hit the bell, because missing one video on this channel could genuinely cost you money. I will see you next week.